mutabani wa Yowana Mirundi ne Mole Namatovu Sir Simon Muyanga Lutaya yagenda okubeera naye ku ssaawa 3 mulengeddeko wabweru awo n'olwekyo toseguka nga batunulira ensonga eziriwo n'ezigenda maaso mu ggwanga. But for now twalabye kooti ya ssemateeka Constitutional Court ngega tegukyali musango. Offensive communication is no longer a crime in Uganda. I've seen a section of Ugandans jubilating, celebrating, saying, yes, at least wakiri. Jukira nti etteeka lino libaddewo nga lifuula offensive communication omusango gwennyini mu ggwanga, naye wiiki twalabye abalamuzi 5 bwe bavuddeyo ne bagamba nti bwetuba nga twogera ku democratic society, eggwanga eritambulira ku demokrasiya, tosobola kuvunaana muntu olwa offensive communication. You are actually going against the tenets eza society erimu eddembe y'okwogera n'ebirala. Jjukira kino kyonna kyaliwo oluvannyuma lwa bannamateeka oba abantu babiri okuli munnamateeka Andrew Kalamagi ne munne Robert Shaka bwe baddukira mu kooti eno eya ssemateeka nga baagala etteeka lino libeere nga liggyibwawo oba akawaayiro kano section 25 mu Computer Misuse Act ng'eggyibwawo nga balowooza nti it is illegal and it violates liviolatinga eddembe ly'Abannayuganda ery'okwogera. So many of us were anxiously waiting. Remember, this happened in 2016. Kuva mu 2016 abakulu bano Robert Shaka ne Andrew Kalamagi munnamateeka bwe baddukira mu kooti. And so we are counting nearly 7 years nga omusango guno gye guli okuweza kugenda mu maaso. And ojjukira ne mabega county Honorable Muhammad Nsereko omubaka wa Parliament wa Kampala Central naye yavaayo n'abaako enongosereza zakola mu tteeka lino. And now court says bwino akawaayiro kano ba section eno eya 25 producer gwenjagala abeere nga agikulaga ku screen yo obeere nga ogiraba nti emenya mateeka, it infringes on the rights of the people of Uganda, a country that claims to be democratic. So nalabye pano y'abalamuzi 5 nga kuliko ne Deputy Chief Justice Kenyini omwami ono Richard Butera nga bagamba nti it is unconstitutional and they ruled section eno ejjibwewo, section eyo eya 25 mu tteeka lino erya Computer Misuse Act. Now this morning we are going to be asking so many questions. Nga bw'olaba ku screen yo gwaliko Baba TV eye section eyagiddwa mu tteeka eya 25 egamba nti any person who willfully and repeatedly uses electronic communication to disturb or attempt to disturb the peace, quiet, and right of privacy of any person with no purpose of legitimate communication, whether or not a conversation ensues, commits a misdemeanor, and is liable to conviction to a fine of not exceeding 24 currency points or imprisonment not exceeding 1 year or both. Njidamu etteeka lino rather section mu tteeka erya Computer Misuse Act eyaggiddwamu ega nti any person who willfully or repeatedly uses electronic communication to disturb or attempt to disturb the peace, quiet, and right of privacy of any person with no purpose of legitimate communication, whether or not a conversation ensues, commits a misdemeanor, and is liable to conviction to a fine not exceeding 24 currency points or imprisonment not exceeding 1 year or both. That was the section that was removed, that was dropped from the Computer Misuse Act by the Constitutional Court. kakati enchayo nako olwali tugenda kubeera nga twegattibwako munnamateeka Joel Roy Musinguzi okwongera okutegeera what actually this means for Uganda, a country, like I said, claims, according to authorities, to be democratic, because bwe twogera ku nsi eri democratic tetutunulira butunulizi bigambo. There are ingredients, waliwo ingredients as describing ensi etambulira ku musingi gwa demokrasia, nti bweba Uganda oba any other country waliwo A, B, C, D. And according to this ruling, clearly kiraga nti bw'ogamba kungu nti yakoseza essimu ye oba any other device na kunyiiza oba nagezaako okwogera ebintu ebisobola okumalako eddembe lyo nti musango. Therefore that ceases to be a democratic country according to this ruling eya kooti eya ssemateeka. So that clearly shows nti waliwo ebirina okubeera nga bitunuulirwa eggwanga okuliyita eritambulira ku musingi ogwa democracy oba demokrasia. These certain things must be met, certain ingredients must be there. So this ruling specifically yajjeyo ekyo nti bwe tuba twogera ku ggwanga eri democratic, offensive communication ceases to be a crime. Now, where does this leave etteeka ddyo lyonna erya Computer Misuse Act, and where does this leave ennongoosereza Honorable Muhammad Nseko ze yakola luli, and again kirekawo bannayuganda, because this is just a section eya 25 the entire law. And now what does it mean eri bannayuganda? It is the reason I have been joined by Joel Roy Musinguzi Muchunguzi, yes, one of the, well, one can say youngest but smartest lawyers in the country we have at the moment, is here. A very good morning to you, sir.
Good morning.
Happy to have you.
Thank you for having me. It's a pleasure to, first of all, talk about a small step that has been taken by our nation towards realizing the freedom of expression that is guaranteed to us by the Constitution, and finally know that our courts are actually recognizing this and confirming it to the people.
We shall get back to that. So,
good morning to our viewers. Thank you very much for tuning in to Baba TV. My name is Joel Roy Muchunguzi. I'm an associate at Signum Advocates and an enthusiast of the freedom of expression. So I thank you for...
okay, well, to start with,
yes.
You just said a small, you're calling it a small thing, a small step?
Yes.
Why do you call it a small step?
When you look at the Computer Misuse Act that was passed in 2011 and has recently been amended in 2022 on the prompting of Honorable Mohammed Nsereko. It is a law that contains not just Section 25, which has been used to prosecute several people, but it also has several other laws which will be falling on the same knife that Section 25 has just fallen on. Section 24, that is right before Section 25, speaks to cyber stalking. Section 26 speaks to cyber harassment. And then they have introduced new sections in the amendment which talk about unsolicited information, which talk about things like all those things that they cover come to criminalize conduct that is unspecific, that is vague, that is the same reasons that the Constitutional Court has used to declare this Section 25 unconstitutional. What makes a person sad is that these declarations are not coming out of the blue. Before they pass these laws, they invite people like us to tell them.
Okay, for the benefit of our viewers, many of them are here saying the English is too much.
No.
Tukozeseko ne ku Luganda.
Kyetugezaako kugamba kooti kyeyogedde si kipya yakyogera mu musango gwa Charles Onyango Obo and Andrew Mujuni Mwenda versus Attorney General. Batwala bali babavunana
yes,
for sedition and ekyo nti bayogera ku mukulembeze w'eggwanga bamwogerako obubi ne bagamba nti bapublishinga amawulire nga si matuufu ebintu bwe bityo. Kooti enkulu mu ggwanga lino negamba nti omuntu okupublishinga amawulire nti si matuufu ebintu bwe bityo, those are things that you cannot criminalize.
Okay,
your conduct.
I need to get you very clearly. Court yagambye eki eyokuntiko
constitutional yasemateeka constitutional court kyeyagambye nti etteeka section 25 eya Computer Misuse Act. Computer Misuse Act yetteeka eriri lye baateekawo to regulate nga bw'okozesa kalimagezi si bwe bagiyita
ebyuma
bikalimagezi bwe tubikozesa. So bw'okikozesa obubi eryo lyetteeka
lino lyateekebwawo okulungamya enkozesa ey'ebyuma bikalimagezi, simu zino computer desktops n'ebirala.
Kati basically etteeka kyeryandibadde likola lyandibadde lituguidinga litulaga nti kino wandikikoze kino tewandikikoze. Nga bw'olina naibawo etteeka lino okulaga nti bw'ogenda wano oba oli osusse woolina okukoma. Naye kati constitutional court kyegambye section 25 bwekugamba nti offensive communication negamba nti
let's look at this law. Producer nyongere etteeka lino. This is the law. This is the section that was removed. So let's look at tuliraba. Any person who willfully and repeatedly uses electronic communication to disturb or attempts to disturb the peace, quiet, and right of privacy of any person with no purpose of legitimate communication, blah, blah, blah. So why should such a section be removed?
Kati, that's why I use the example of if you have a neighbor and there is a map or you have a title, the map gives you proper boundaries, right? This is where you should go, this is where you shouldn't go. What the Constitutional Court has actually used to remove this particular provision is that there is no room for legal debate because it has used vague and undefined language. When it tells you disturb the peace, quiet, or right of privacy, none of those words is defined in the law, none of them is defined in the Interpretation Act. Then we come to the purpose of legitimate communication. What do you define as legitimate communication? If I come to you as my leader and I call you a fool or a nincompoop, does that mean I don't have a legitimate purpose to communicate to you? What has been said and echoed by the Supreme Court, which is higher than the Constitutional Court, that's why I told you about Charles Onyango Obo, is that when we are granted the freedom of expression, that freedom is not here to protect polite language and polite discussion only. No, it is there to protect expression, including expression that offends and disturbs. It is not there to...
So does that mean people have the right to insult their leaders?
They do. They do. Especially now, you see, one of the things that you must understand is that...
They have a right?
They do. They do. And I can say that with legal authority from across the world. Especially when you are a leader, you are placing yourself in the public arena so that people are entitled to discuss you, to debate you. So when you say insult itself, I mean, what is to insult? If I say that the law that, for instance, Honorable Mohammed Nsereko passed was an idiotic law, would I have insulted him? Do I have a legitimate purpose for saying that? I believe I have a legitimate purpose because I'm saying that the law that he's bringing carries things like, well, unsolicited information. What is unsolicited information?
So it is vague.
Very vague. Same reasons that have been used to annul Section 25. So you see what disturbs people like us, public interest enthusiasts, is that before passing these laws, there is a parliamentary process that has to be followed. That parliamentary process includes consulting people that are interested in these things. Lawyers, the Uganda Law Society, journalists, they were consulted and they guided. They told them that the Supreme Court has already ruled that this cannot pass the standard of freedom of expression as guaranteed under Article 29. So for them to go on and pass a law, very well knowing that we will come and challenge it, and we will challenge it successfully.
And you've succeeded finally.
Not yet. The ULS still has a petition that is challenging Section 24 and 25.
We shall get back to those other two sections you're talking about. You said 25 and 26, right?
No, you see, before 26. The ULS petition challenges 24 and 25. Now, there is another action by the Legal Brains Trust in the East African Court of Justice. Now, this one is challenging the one, Isaac Semakade and group. They are challenging now the new sections that have been introduced. So, the problem is, you went to court, you passed a law, people went to court, challenged it. They have succeeded. But you continued. People have guided you that this law will not stand. But you continue and pass the law. That means you're asking the Attorney General to go and use public resources to defend something that is obvious.
That is illegal and unconstitutional. Okay, where does this leave the amendments by Honorable Mohammed Nsereko, this ruling? Where does it leave his amendments?
The things that the court has pointed out as not necessary in a free and democratic society are still the same things that are in the amendment to the Computer Misuse Act. The Computer Misuse Act doesn't add a single thing to the law that is not already covered. I mean, the Computer Misuse Amendment Act, that the Mohammed Nsereko bill. The first thing that it attempts to do, when you look at it, is it attempts to sell itself as a law that is here to protect children. Yet, when you look at the Data Protection and Privacy Act, it contains the same provisions, actually better worded provisions that are more clear and precise, that protect children from